Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Certificate in Consumer Protection, CCP, CPI, 102 Redressal of Consumer Grievances, Role of Various Stakeholders, Block-1 Role of Media and State Government in Consumer Protection, Unit to Misleading Advertisement, Regulatory Mechanism, 2.1 Objectives. After studying this unit, the learner shall be able to explain the concept of misleading advertisement, discuss the provision of SI code relating to misleading advertisement, describe the guidelines of the Press Council of India concerning misleading advertisement, discuss various legal provisions dealing with misleading advertisements, and examine the role of Ministry of Consumer Affairs in controlling the misleading advertisement. 2.2 Introduction. Advertising is the most important and effective mode of publicity of the products and services to the consumer. It describes the characteristic of the product and services which help in educating the consumer about the availability of the product and services which suited to his/her needs. However, it has been noticed that in order to increase the sale of the product and services, the companies make false and exaggerated claims about the qualities and effectiveness of their product and service, which are called as misleading advertisements. This unit discusses the various aspects of such misleading advertisement, the self-regulatory mechanisms and various provisions of law which aims at curbing misleading advertisement. 2.3 Advertising as defined by the Advertising Association of the UK. Advertising is a means of communication with the users of a product or service. Advertisements are messages paid for by those who send them and are intended to inform or influence people who receive them. Advertising is always present, though people may not be aware of it. In today's world, advertising uses every possible media to get its message through. It does this via television, print, newspapers, magazines, journals, etc., radio, internet, direct selling, hoardings, mailers, contests, sponsorships, posters, clothes, events, colors, sounds, visuals, and even people endorsements. Advertisement is a facet of right to information. A vital aspect of advertising that makes it a part of Article 19(1)(a) is that it facilitates the dissemination of information about who is selling what product and at which price. Advertisements help people make well-informed and intelligent economic choices. More important than the right of expression of the advertiser is the right of the recipient of the advertisement. The Supreme Court observed in Tata Press v. Mahanagar Telephone Nigam Limited, Article 19(1)(a) not only guarantees right of freedom of speech and expression, but it also protects the right of an individual to listen, read and receive commercial speech. So far the economic needs of a citizen are concerned, their fulfillment has to be guided by the information disseminated through advertisement. The recipient of commercial speech may be having greater interest in the advertisement given. Such deeper interest can be dealt with dishonesty by the advertiser, as the consumer totally rely on the information provided by the advertiser through the advertisement of the given product. 2.3.1 Misleading advertisement. Any advertisement or promotion through television, radio, or any other electronic media, newspapers, banners, posters, handbills, wall writing, etc. to misrepresent the nature, characteristics, qualities or geographic origin of goods, services or commercial activities so as to mislead the consumer could be broadly defined as a misleading advertisement. Thus, misleading advertisement include exaggerating and overstating, expressing unrealistic attributes of the product, use of professional concepts for more effect, fake license, false warranties, use of cinematic tricks and misleading images, discounts and gifts. 2.4 Advertising Standards Council of India, ASI, competition in the market has been growing as a result of developing economy and progress. Marketing practices, advertising and marketing communication were becoming competitive, and a need was felt by all those connected with advertising to ensure fair play among all the players. During 1985, prominent members connected with all aspects of advertising came together and decided to accept global best practices in the field of self-regulation in advertising. It was observed that specific bodies were in existence in developed markets such as the USA, UK, Germany, which were known as SROs, Self-Regulatory Organization. Advertising Standards Council of India, ASI, was formed on the lines of best practices in the field of self-regulation in advertising. The Advertising Standards Council of India, ASI, was established in 1985. It is committed to the cause of self-regulation in advertising, ensuring the protection of the interests of consumers. ASI was formed with the support of all four sectors connected with advertising, viz. Advertisers, advertising agencies, media, including broadcasters and the press, and others like PR agencies, market research companies, etc. ASI seeks to ensure that advertisements conform to its code for self-regulation. Gradually, the ASI code received huge recognition from the advertising industry. The warnings issued by ASI to the advertisers against the misleading advertisements were gradually being accepted by the advertisers, and the advertisements were actually stopped being aired or modified significantly to comply with the prescribed ASI code. Nonetheless, the ever-increasing role of ASI in regulating advertising practices in India was felt by the government too, and in August 2006, the ASI code was made compulsory for TV advertisements. The rules were also amended as follows: no advertisement which violates the code for self-regulation in advertising, as adopted by the ASI for public exhibition in India, shall be carried in the cable service. This move has provided a binding effect on the ASI code. 2.4.1 ASI code. In January 2017, ASI came up with a new advertising code. The ASI code aims to protect the legitimate interests of the consumers by regulating false, misleading, and objectionable advertisements broadcast on television, radio, and internet by advertisers, media, and advertising agencies. The key objectives of ASI code is to ensure that advertisements must make truthful and honest representations and claims, which is essential to prohibit misleading advertisements, not be offensive to public decency or morality, not promote products which are hazardous or harmful to society or to individuals, particularly minors, and observe fairness in competition, keeping in mind the consumer's interests. Chapter I of the Code extensively deals with the truthful and honest representation. Some of the important provisions of this chapter are: advertisements must be truthful in all descriptions, claims and comparisons which relate to matters of objectively ascertainable fact. Where advertising claims are stated to be based on or supported by independent research or assessment, the source and date of this should be indicated. Advertisements shall not, without permission from the person, firm or institution under reference, contain any reference to such person, firm or institution which confers an unjustified advantage on the product advertised or tends to bring the person, firm or institution into ridicule or disrepute. Advertisements shall neither distort facts nor mislead the consumer by means of implications or omissions. Advertisements shall not be so framed as to abuse the trust of consumers or exploit their lack of experience or knowledge. No advertisement shall be permitted to contain any claim so exaggerated as to lead to grave or widespread disappointment in the minds of consumers. Obvious untruths or exaggerations intended to amuse or to catch the eye of the consumer are permissible provided that they are clearly to be seen as humorous or hyperbolic and not likely to be understood as making literal or misleading claims for the advertised product. In mass manufacturing and distribution of goods and services, it is possible that there may be an occasional, unintentional lapse in the fulfillment of an advertised promise or claim. Such occasional, unintentional lapses may not invalidate the advertisement in terms of this code. In judging such issues, due regard shall be given to the following: a. Whether the claim or promise is capable of fulfillment by a typical specimen of the product advertised. b. Whether the proportion of product failure is within generally acceptable limits. c. Whether the advertiser has taken prompt action to make good the deficiency to the consumer. 2.4.2 Complaint under ASI Code. Under the ASI Code, complaints against the advertisements can be made by any person who considers them to be false, misleading, offensive, or unfair. The complaints are evaluated by an independent Consumer Complaints Council (CCC), which has 21 members, 12 from general public and 9 from advertising practitioners. There are 3 types of complaints handled by ASI: a. Complaints from the general public including government officials, consumer groups, etc. b. Suo motu complaints from the member of the ASI board (CCC) or the secretariat, and c. Intra-industry complaints from one advertiser against another. On receipt of a complaint, the secretariat acknowledges the complaint and requests the advertiser or agency to provide comments in respect of the complaint. The CCC usually decides upon the complaints within a period of 4 to 6 weeks once the party concerned is afforded an opportunity of presenting its case. If the complaint is upheld, then the advertiser and its agency are informed of the CCC decision within 5 working days. The advertiser is given 2 weeks to comply with the CCC decision. Non-compliant advertisements are published in ASI's media quarterly release on an all-India basis. 2.5 Press Council of India. The Press Council of India (PCI) was first set up in the year 1966 by the Parliament on the recommendations of the First Press Commission with the object of preserving the freedom of the press and of maintaining and improving the standards of press in India. Press Council is a mechanism for the press to regulate itself. The purpose of this unique institution is rooted in the concept that in a democratic society the press needs to be free and responsible. If the press is to function effectively as the watchdog of public interest, it must have a secure freedom of expression, unfettered and unhindered by any authority, organized bodies or individuals. But this claim to press freedom has legitimacy only if it is exercised with a due sense of responsibility. The press must, therefore, scrupulously adhere to accepted norms of journalistic ethics and maintain high standards of professional conduct. Press Council of India Guideline Number 36 deal with advertisements. With regard to misleading advertisements, it provides the following: I. Non-publication of advertisement which promotes directly or indirectly production, sale or consumption of cigarettes, tobacco products, wine, alcohol, liquor and other intoxicants. 2. Rejection of advertisements which offend the provisions of the Drugs and Magical Remedies, Objectionable Advertisement Act as amended in 2002 or any other statute. 3. Rejection of advertisements containing anything which is unlawful or illegal, or is contrary to public decency, good taste or to journalistic ethics or propriety. 4. Advertisements must be clearly distinguishable from editorial matter carried in the newspaper. Newspapers, while publishing advertisements, should specify the amount received by them. Non-publication of dummy or lifted advertisements that have neither been paid for nor authorized by the advertisers. 6. Total coordination and communication between the advertisement department and the editorial department of a newspaper in the matter of considering the legality, propriety, or otherwise of an advertisement received for publication. 7. Newspapers to carry caution notice with matrimonial advertisements carrying following text. Readers are advised to make appropriate, thorough inquiries before acting upon any advertisement. This newspaper does not vouch or subscribe to claim and representation made by the advertiser regarding the particulars of status, age, income of the bridegroom. 12. An editor shall be responsible for all matters, including advertisements published in the newspaper. If responsibility is disclaimed, this shall be explicitly stated beforehand. 2.6 Laws governing advertisement in India. There is no single law which comprehensively deal with the issue of misleading advertisement. Different laws deal with different aspects of misleading advertisements. Some of the laws are discussed below. 2.6.1 The Consumer Protection Act, 1986. The Section 6 of this Act grants consumers the right to be informed about the quality, quantity, potency, purity, standard and price of goods or services, as the case may be, to protect the consumer against unfair trade practices. Section 2(r) of the Act, under the definition, the term unfair trade practice covers the gamut of false advertisements including misrepresentations or false allurements. Redress against such unfair trade practices on false advertisements may be sought under the Act. The proposed amendment in the Act makes celebrity brand ambassadors accountable for endorsing products that make unrealistic claims. It proposes to provide for a jail term of up to 5 years, apart from a penalty of 50 lakhs rupees for false and misleading advertisements. Section 75B of the new bill seeks to make any false or misleading endorsement which is prejudicial to the interest of any consumer a penal offence, punishable with a jail term of up to 2 years and a fine of 10 lakhs rupees for the first offence, and imprisonment of 5 years along with a fine of 50 lakhs rupees for the second and subsequent offences. The proviso to Section 75B, however, says that liability could be dodged by proving that the celebrity endorser took all precautions and exercised due diligence before endorsing a product or service. The proposed law, however, lays down that no court shall take cognizance of such an offence except upon a complaint made by an officer of the Central Consumer Protection Authority, duly authorized by the Chief Commissioner. A central authority has been proposed as a new executive agency to fill an institutional void in the regulatory regime extant. Further, the new law also allows for the compounding or settlement of the first offence by brand ambassadors, and the central authority, the government's department, has been empowered to do so. So, a charge of false and misleading advertisement can be dropped if the brand ambassador shells out monetary damages. If the prosecution has already begun in a trial court, the central authority could still seek exoneration of the brand ambassador by moving an application before the court, the proposed law states. If the court is satisfied, the accused may be discharged. The bill also lays down that no proceeding, judicial or otherwise, can be instituted against a brand ambassador if the offence has been compounded under the law. 2.6. The Cable Television Network Act, 1995. Section 6 of the Cable Television Networks Regulations Act, 1995 provides that no person shall send or transmit through a cable service any advertisement unless such advertisement is in conformity with the advertisement code prescribed under the Cable Television Networks Amendment Rules. 2006, however, the provision above does not apply to programs of foreign satellite channels which can be received without the use of any specialized gadgets or decoder. Rule 7 of the Cable Television Networks Amendment, Rules 2006 lays down the advertising code for cable services which have been formulated to conform to the laws of the country and to ensure that advertisements do not offend morality, decency and religious susceptibilities of the subscribers. 2.6.3 Cigarettes and other tobacco products, Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply and Distribution, Act, 2003 Section 5 of this Act, prohibits both direct and indirect advertisement of tobacco products in all forms of audio, visual and print media. 2.6.4 Drug and Magic Remedies Act, 1954 and Drugs and Cosmetics Act, 1940. This act is for regulating the advertisements of drugs in certain cases and to prohibit the advertising for certain purposes of remedies alleged to have magic qualities and to give for matters connected therewith. Section 29 of the Drugs and Cosmetics Act, 1940 imposes a penalty upon whoever uses any report of a test or analysis made by the Central Drugs Laboratory or by a government analyst, or any extract from such report, for the purpose of advertising any drug. The punishment prescribed for such an offence is fine which may extend up to 500 rupees and imprisonment up to 10 years upon subsequent conviction. 2.6.5 Prenatal Diagnostic Techniques, Regulation and Prevention of Misuse, Act, 1994. Advertisement in any manner regarding facilities of prenatal determination of sex available at any genetic counseling center, laboratory, clinic or any other place is prohibited under this Act, 1994, and has been made a punishable offence under the Act, 1994, Section 22. 2.6.6 Young Persons, Harmful Publications, Act, 1956. Section 3 of the Young Person Harmful Publication Act, 1956, inter alia, prescribes punishment with imprisonment which may extend to 6 months, or with fine, or with both for advertising or making known by any means whatsoever that any harmful publication, as defined in the Act, 1956, can be procured from or through any person. 2.7 Department of Consumer Affairs. Department of Consumer Affairs, DCA, is one of the two departments under the Ministry of Consumer Affairs, Food and Public Distribution. It was constituted as a separate department in June 1997 as it was considered necessary to have a separate department to give a fillip to the nascent consumer in the country. The department has been entrusted with the enforcement and monitoring of the provisions of the following Act work: the Essential Commodities Act, 1955, 10 of 1955, Supply, Prices and Distribution of Essential Commodities not dealt with specifically by any other department. Prevention of Black Marketing and Maintenance of Supply of Essential Commodities Act, 1980, 7 of 1980, Regulation of Packaged Commodities. Training in Legal Metrology. The Emblems and Names, Prevention of Improper Use, Act, 1952. The Legal Metrology Act, 2009. Implementation of Standards of Weights and Measures. Bureau of Indian Standards Act, 1986. Implementation of laying down specifications, standards and codes and ensuring quality control of biofuels for end uses. Implementation of Consumer Protection Act, 1986. Internal Trade Consumer Cooperatives Monitoring of Prices and Availability of Essential Commodities. National Test House. The mandate of the department is consumer advocacy. In its endeavor to address the problem of misleading advertisements, the Department of Consumer Affairs has launched the portal gov.in, Jago Grahak Jago, for registering online complaints for grievances against misleading advertisements, GAMA. Tackling unfair trade practices and misleading advertisements requires mobilization of all agencies with state governments, voluntary consumer organizations, VCOs, Grahak Suvidha Kandras, Advertisement Standards Council of India, ASI, Indian Institute of Public Administration, IIPA, and various regulators of the central government. The focus will be on 6 key sectors viz. Food, agriculture, health, education, real estate, transport and financial services. Regulators for each of these sectors will be key partners in the success of the effort to prevent the problem. 2.8 Summary. Advertisements are the paid messages through television, radio, newspapers, magazine, hoarding etc. which are intended to inform or influence people. Advertisements help people to make well-informed and intelligent choices. Any advertisement which misrepresents the nature, characteristics, qualities or geographic origin of goods, services or commercial activities so as to mislead the consumer can be broadly defined as misleading advertisement. Since independence, advertisements has become competitive and a need was felt to ensure fair play among all the players. During 1985, prominent members connected with all aspects of advertising came together and decided to accept global best practices in the field of self-regulation in advertising. Thus, the Advertising Standards Council of India, ASCII, was formed. It is committed to the cause of self-regulation in advertising, ensuring the protection of the interests of consumers. ASI entertained and disposed of complaints under its code which is known as ASI Code. This code was last revised in January 2017. The ASI Code aims to protect the legitimate interest of the consumers by regulating false, misleading and objectionable advertisements. The Press Council of India guidelines also deal with the control of misleading advertisement. These guidelines provide inter alia rejection of advertisement prohibited under the Drugs and Medical Remedies Objectionable Advertisement Act as amended in 2002. Advertisements should be clearly distinguishable from editorial. Prohibition of the publication of dummy or lifted advertisement. In India, a number of laws relating to advertisement control have been passed. Important among them are Consumer Protection Act, 1986, the Cable Television Network Act, 1995, Cigarettes and Other Tobacco Products Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply and Distribution Act, 2003, Drugs and Magic Remedies Act, 1955, Prenatal Diagnostic Techniques Regulation and Prevention of Misuse Act, 1994, etc. It is the mandate of the Department of Consumer Affairs to promote consumer advocacy. It has launched the portal Gama. Government.in Jago Grahak Jago for registering online complaints against misleading advertisements. Thank you. Subscribe to our channel for more updates, and we will see you with the next chapter.